Any bill introductions? Are there any bill introductions? Seeing none, this time we're going to have a hearing on Senate Bill 316, and to explain the bill authorizing the municipalities to adopt local zoning regulations that establish a minimum distance between group homes and single-family residential zones. Good morning, Jason.
Morning, Madam Chair, members of the committee. Senate Bill 316 amends one statute, 12-736. This statute deals solely with regulating zoning and other municipal regulations of group homes. You'll see on the first page of the bill, group home is defined in statute as a dwelling occupied by not more than 10 persons, 8 or fewer of whom have a disability as defined in the bill. This is essentially somewhat of a state codification of the Federal Fair Housing Act that prohibits discrimination in housing against individuals with disability. The bill, the statute, underlying statute currently prohibits any municipal regulation that would prohibit a group home from being placed in a zone or area where single-family residences are permitted. It also prohibits any municipal regulations on group homes that are applicable only to group homes. It would not be applicable to other single-family residences in the same zone or area. So you generally cannot have a special regulation for group homes in an area where there are single-family residences. Senate Bill 316 makes a narrow exception to that general prohibition by authorizing municipalities to establish a minimum distance requirement between group homes. That would be a quarter mile, 1,320 feet from lot line to lot line between group homes. So if you have a group home in a zone or area, a new group home is looking to build in that same zone or area, and if the municipality has this regulation on the books, then that group home would have to make sure its property line was at least a quarter mile from the already existing group home. The municipal regulation must also have provisions that grandfather in any group homes that are in existence as of July 1st, 2022. And so they could adopt that one particular regulation that would be only applicable to group homes and not to single-family residences. I will just mention to the committee that any municipality that does take advantage of this bill, if it's enacted, would still need to make sure that they're in compliance with the Federal Fair Housing Act and its prohibitions on discriminatory regulations. And so there would be still the necessity to review it in light of that act. But the bill would go into effect on July 1st of this year, Madam Chair, and I'd be happy to answer any questions.
Are there any questions for Jason? I don't see any. Senator Francisco.
Thank you, Madam Chair. I see that the group home talks about persons with a disability, so this would not apply to a group home for youth?
No, this is specifically just the group homes as defined under this statute.
Thank you.
Other questions? I don't see any at this time. Thank you, Jason. All right, we have several conferees, and in order to get done within our timeline, it looks like you may have about 5 minutes so that we can maybe perhaps have a few minutes at the end for questions. And please don't read your testimony, and if you go past your time, I will let you know. This time we have Senator Fausto.
Good morning, Madam Chair, Senator McGinn, Bowers, Francisco, and the other esteemed committee members of the Senate Local and Government Committee. Madam Chair, I live in Wichita, Kansas. I reside in the Lambsdale's Neighborhood Association neighborhood. In that area, we are fortunate to have a lot of ranch-style homes that are flat. For the past 3 years, this issue has been growing, and was brought to my attention by members of the neighborhood association that while we do welcome group homes in the neighborhood, it has become really concentrated. Madam Chair, just for an example, or first I want to say this, I ran for office to help people with disabilities, senior citizens, and I support them living in their homes and in communities. My mother was in a wheelchair before she passed, so I'm not opposed to the group homes. I just feel that personally, living in the community, there were 2 empty houses on either side of me, and a house empty across the street from me. And fortunately, a group home tried to buy the house, or individual tried to buy the house next to me to turn it into a group home. That didn't happen. Actually, my vice mayor, my city council member, Brandon Johnson, moved in next door to me. And so, again, my understanding is that all we want out of this simple bill is to put a distance between a group home. I don't know any, you know, like I said, I could have had a group home on either side of me and one across the street from me. And so again, I'm honored to have introduced Senate Bill 316 on behalf of the Lambsdale's Neighborhood Association, and our president of the Neighborhood Association is here today. So I am going to yield so that others who have traveled will be able to testify. But again, Madam Chair, thank you for the opportunity, and I would appreciate the support from the committee for Senate Bill 316. Thank you, Madam Chair. And I'll answer questions at a...
I just have a quick question.
Sure.
From being in that area. Could you give me the main intersections of where Lambsdale?
So, yes, our boundaries are, so 13th and Edgemore-ish, and then it goes to Edgemore and Central, 13th Street going east to Woodlawn, and then 13th and Oliver, near the post office. And it does pick up Sleepy Hollow area, near Wesley Medical Center. Thank you.
I want to know about where it's at. Thank you.
Thank you, Madam Chair.
All right. Next, we have Representative Henry Helgerson. Welcome to the committee.
Thank you very much. Let me set the stage a little bit, first of all. 1970s, 1980s, 1990s, and the federal government and the state government had made a conscious decision to move people from the state hospitals and into the community settings. As part of that, there was a need for additional group homes. And what was happening in the 80s and 90s in particular was that there was restrictions being placed on the community, on the group homes. As a result, the legislature passed at that time protections to allow group homes to come in without any restrictions into the neighborhoods. If you look closely, my name is on half a dozen of those documents and bills. I'm a strong favor then and still are. But what we have seen, though, is a concentration of those within select neighborhoods. And the problem with that is that it distorts partially the neighborhood itself, as opposed to having an interaction between the neighbors and the group homes. You have a series of group homes without any interaction to the neighbors itself. Second, you also see property values gone down because people see a group home and are hesitant to do that, move into the area, and so the property values go down. And third, it's a self-fulfilling prophecy. I say that because if you don't sell a home, then an investor or some other entity is going to move in because they can buy it at a better price and move in. And that's what's happened in this neighborhood. It's a concentration of group homes, which was never intended in the legislation that was introduced. All of us are in favor of having strong integrated group homes into the neighborhoods. But none of us have ever said in the legislation that went on in the 90s and the 90s in particular, that we wanted to congregate them into just a select areas of the cities. That's why I think it's time to go back and revisit the legislation and look at some kind of minimum restrictions on this. I'd be happy to stand for any questions now or later.
Oh, since you're a representative and may have to go, is there any questions for the representative? Senator Hayden.
Thank you, Madam Chair, and thank you, Representative Helgerson and Senator Falscadeau and Abstensia. Why is this not a local issue? Why is this a state issue? I'm just missing why the council, the city council or other areas might undertake to decide proper zoning.
I believe that they're restricted under federal law. And so you have to have a state, and this has been talked about for several years. State has to intercede and say, this is the restriction. It's fairly limited, but we give the power to the local communities. I think that there's interest in doing that in Wichita, but I know that there's interest in doing that in Wichita, but they have to have authority from us.
Okay, thank you. Thank you, Madam Chair.
Thank you.
Senator Bowers.
Thank you, Madam Chair. Hello, Representative. Just a quick question. Was this discussed when you worked on this years ago? Was there boundary lines or distance discussed in the original conversation?
The original conversations goes back in the 90s, and that's testing my memory a little bit. We never envisioned that there would be a concentration of not-for-profit and profit homes moving into a 3, 4, 5, 6 block area. It's the economic conditions that have created this, the structure of the houses themselves, that have led to this one phenomenon. No one ever brought up the idea that we'd have a concentration. We were just trying to make sure that there was one home or 2 homes in a city, and so that we could expand. But no one ever thought about bringing them all in.
Thank you, Madam Chair, and thank you, Representative.
Other questions? Senator Thompson.
Just one quick question. That's a quarter mile basically apart, and I know we're having some of that issue in our district with some of the municipalities. So this would just basically, I guess my big question, I was looking at the fiscal note, wouldn't the municipalities enforce this if we put it in? Because I don't think 166,000 from KDADs, that seems a little bit high.
Seems real high.
It seems real high. I mean, when the cities would just have the opportunity to use this statute to enforce that setback distance, correct?
I haven't looked at the fiscal note, but you said it's 166,000?
That's what I just read real quickly. Yeah, it seems seems like a money grab to me, but I mean, basically, we're just telling the cities they can say, hey, you need to space these things out so we're not affecting the property value of people, because the Home Plus homes are already coming into communities.
I would disagree with the fiscal note also, and if this goes further, I probably have additional conversations with the Secretary.
Thank you. Thank you, Madam
Last
Chair.
question for the representative, Senator Warren.
Thank you, Madam Chair, and thank you, Representative, for appearing today in committee for your testimony. Have you, as a proponent of the bill, talked with the municipality where you see this situation occurring? Have you talked with the city of Wichita?
I've talked with the city, and I also talked with the Secretary previously in past years.
And what is their position been? I don't see any testimony either way from the city of Wichita.
City of Wichita has told me previously that they're acceptable with the idea, but they didn't think they'd have any opportunity to do anything unless we pass the legislation. We have the vice mayor who now lives in the area, and I have not visited with him, but I understand that he's supportive of the idea.
We don't have any testimony. Okay, thank you. Thank you, Madam Chair.
All right, I said last question, but you apparently didn't hear. Senator Dahl.
Sorry, Madam Chair. I can't hear very well. This doesn't smell right or taste right. Is this even constitutional? This seems like to me that we are taking a part of the population and telling them they can't live in a certain place. you know, we dealt with this in the 50s, the 60s, and the 40s, and everywhere else. I really have a problem with this. Is this constitutional?
Not being an attorney, even if I was an attorney, I wouldn't know for sure. I think that there has been legitimate concerns over the years whether or not it's constitutional. That's why it's drawn in very limited way, saying that you can have only so many within that area of town, within that distance. I think that should be looked at. I also think that if it's unconstitutional or if it's questionable, we should push the item. We should go and ask ourselves, how do we get better quality homes, and how do we do it for the neighborhoods that's constructive for all parties? You know, I can guarantee that this was never talked about when the legislation was passed here in this building. And that's why we should revisit it again. It may raise questions, or there may be advocates that say, we don't want you testing this at all. But I think that's important, and that's what our job is to do, is to test to see what's appropriate for a balanced approach. And let me also say, what I found in walking this neighborhood on a regular basis, you know, we had the idea that this would be having the homes in the neighborhood is the ideal situation, you know, because then we'd have an interaction between the people that own the single-family homes and those individuals that are in a group home. I can tell you that they're like walled state hospitals at times. Some of them are. There is no interaction between the neighbors next to each other. And that's the shame. And maybe we should go back and look at it all and say, why isn't there more interaction between neighbors and group homes? Because that's how it was all designed. That's how it was identified on the House floor and the Senate floor. So I think that yes, you raise a legitimate question, but it should be tested and it should be pushed farther to make it a better environment for all the population.
Okay, I think we're going to move on. Thank you, Representative. I think it's more of a societal problem that people don't talk to their neighbors anymore too, but that's another issue. Next, we have Glenn Burdick, President of Lambsdale Neighborhood Association. Welcome to the committee.
Good morning, Madam Chair McGinn, Senators. Thank you for allowing me to address you this morning. I am Glenn Burdick. I am the president of the Lambsdale Neighborhood Association in Wichita, Kansas. Let me start by saying the reason we brought this forward is not to ask you to prohibit group homes in the area. It's to let you know about the concentration and the effects of that concentration is having upon us. So we want to be able to allow group homes. We do have a neighbor that operates a group home. They're a great neighbor for us. They're a full participant in our neighborhood association. But you know, we're a small neighborhood. We're 120 houses, and then we associate with another 10 or so houses. So we're an area of less than half a mile. And in our half-a-mile area, we have 8 group homes. On one block, we have 4 group homes, two each next to each other and then facing each other. So what has been allowed to happen is we've got a concentration of group homes. This is no longer a residential area for families that are trying to be neighbors and to live. We've allowed a business to zone in there. And one of the reasons is because of the current statute we're asking you to change today. It is very open on the fact that if the area is zoned single-family housing, then the city, the municipality is not allowed to offer any other restrictions. And that's the change we're asking for you today, to allow us, a municipality, for us as a neighborhood to go to our commissioners and ask that new group homes be spread out. What's happening in our neighborhood, we're single floor plan houses, ranch style homes. It's real easy for a business or investor to come in and to outbid a family that is trying to move up into their next house and into our neighborhood. We're a nice, quiet neighborhood, but we're losing out because we can't space out the group homes. we're having problems with some of the group homes. Back in 2018, we had a group home that focuses on mental health, and the residents of the group home and the management were having troubles with one another, and they saw the solution is to call 911. Every disagreement in the group home, it was a call to 911. The police were out there. I believe the report, it's in your notes, we had 24 hours in 1 year of police calls. And in one case, the call to the police was of such significance that the police decided to block off access to the block, and it's an extremely long block. Nobody could get in and out until they could get into the home and determine what the problem was and if there was a problem at all, and it turned out there wasn't one. And the police finally had to come back to the management of the group home and tell them, if you don't correct the problems, get a handle on the residents, get a better working relationship with your residents, then we're going to park a police officer outside your home. By city nuisance laws, we're allowed to charge you for that police presence, and it goes for at least a year. Fortunately, we were able to diffuse the situation and not have that happen. But along with this other group home, we've had the residents come through. I had the knock on my door. Do you have any cigarettes you could give me? Or can you give me some change for cigarettes? Now, I don't mind a neighbor knocking on my door, but a cup of sugar I'm glad to give. But I'm not a supporter of cigarettes. The other things we've had issues with the group home, of course, with the concentration of the four, that's quite a traffic issue around shift changes or when the nurses all come to see the residents or when family members come. The street is pretty much blocked off as all those cars pile up. Another incident we've had, the trash can overflows. And there is trash that's not kitchen waste that is piled around the garbage can until somebody can go out and pick it up. And in case of one of the homes, they're a little slow. So as to the question of, will this pass the federal fair housing laws? I've done research in this, and there's a lot of papers out there on, the NIMBY, not in my backyard type of complaints where not only do you want a group home, but you want a hazardous waste, you want a business, you want something that's high traffic. And a lot of those have been taken before federal courts. And the federal court rulings that I've been able to find seem to say, yes, as long as you're permitting group homes in your area, but if you have restrictions and the restrictions are there to change the character of the neighborhood back to residential, encouraging single-family housing, encouraging neighbors to interact with one another and to have a true family setting, then that is acceptable to the federal housing standards. So that is the reason I'm before you today. We're asking the committee and the state to help out our neighborhood. And it's just not our neighborhood. As Representative Helgerson has mentioned, it's other areas along the city of Wichita, out in the Maze area off of 13th Street. It's all flat houses there. They have quite a concentration. I'm not even sure if Representative is aware, but across Woodlawn from Eastboro where he lives, there's another concentration of 3 or 4 housing. So it changes the character of the neighborhood. It makes it so if we have a problem with our neighbor, as I've discussed, you're interacting with 3, 4, in our case, 8 different management companies trying to find solutions instead of being able to talk to a neighbor and coming to an understanding. So we're here before asking if the state will please put in a change to the law that allows a municipality to restrict the concentration and to spread things out.
Thank you, Mr. Burdick.
Thank you.
And I assume you'll be able to stay if we have time for questions at the end?
Gladly.
All right, thank you. Are there any other proponents who would like to speak? Seeing none, we're going to,
Madam Chair, I just got a text message from Councilman Brandon Johnson, who lives in the neighborhood, and if he's able to join us
well, I'm going to
virtually.
get the people who are on the list first, if that's okay, because I don't know who's from out of town. So at the end, we'll get him on. Thank you. At this time, we're going to go to the opponents, and we have Liz Long from the Kansas Council of Developmental Disabilities. Welcome to the committee.
Hi. This is the first time I've appeared before this committee, so I'll introduce myself. I'm Liz Long, and I'm with the Council on Developmental Disabilities. I'm here to oppose 316 and to support Kansans with disabilities to express their right to live where they choose. The fact that they might need to have roommates to afford to live in a community or staff to assist them with day-to-day tasks should not limit their choice in housing. The point of community-based living is to avoid institutionalized housing, which restricts people's choice of where they live and who they live with. And personal choice is a basic right we all cherish and should not be limited by others because of your disability. We all want neighbors we like, who watch out for each other, who shovel each other's walk, let you know when the garage door is open or your pet's wandered off. No one wants to live in an industrial park, whether you have a disability or not. While some people sometimes get uncomfortable around people who look or speak differently, persons with disabilities are not to blame for that discomfort. Some people are concerned about traffic or parking in their neighborhoods. I would like to point out the neighborhoods already have significant traffic. Lawn service, pool, housekeepers, FedEx, UPS, list goes on and on. You all may have Meals on Wheels or a grocery store delivery. Adding someone's staff to that list to allow for the important work of medication administration, cooking, or bathing support seems like a minor addition to existing traffic. So it would seem limiting the number of unrelated people who can live in a house or number of cars they can own or visitors that they can have might be a fairer piece of legislation rather than singling out people because of their disability or their supports they're needed. And as representatives of all Kansans, I urge you to consider the far-ranging impacts of this suggested piece of legislation. Thank you. I'll stand for questions.
Thank you. Next, we have Sean Gatewood from the Can Care Advocates Network.
Thank you, Madam Chair, members of the committee. I'm happy to be here in front of you today. Allow me a second to introduce myself. This is not a committee I'm used to. Typically, I'm in front of the health committees. The Can Care Advocates Network is a group of organizations and people that are served by the Can Care program. We are cross-age, cross-disability, and we advocate for folks to be able to live in the most integrated setting in the community as possible for that individual. That is what brings me here today. We obviously are here to oppose any kind of a ceiling or artificial, governmental limit on where people with disabilities can live. We work very hard in this institution to draw down additional resources and whatever we can do into the Medicaid program to allow people to live in the community where they frankly should be. And as state officers, I think in your interest and in the interest of the community, we want to see the best outcomes for people as humanly possible. And having folks living in those more integrated settings is shown time and time again to be the best thing for them. It's the best thing for the community. So that kind of brings me to exactly why we're having this discussion today, and that is, it seems to me that this neighborhood has a couple of things that are very much going for it. Number one, they are made up of a number of houses that are sort of ranch-style, ground-level houses that are easily made into accessible housing. Yes, there's going to, there could be a tendency to concentrate, but that is the same reason that you're going to have older people moving into your neighborhood because, as we get into our whatever age, the stairs start to look a little bit tougher. I mean, my house, I'm going to be rethinking this decision in a few years, right? We're all going to be facing that. And that is a real issue. Well, that is why, the state gives a certain amount of money for providers to, take care of these houses and make them accessible for folks. So ground level housing is a place that they can do that with the resources that they're given. To those that are in the neighborhood, I say congratulations. You get to age in place into your home. That's one of our biggest goals at the Can Care Advocates Network. We want folks to be able to stay in their home as long as they possibly can. We want people to be able to live in the community, and this is a neighborhood that you can do that. So be proud and be happy that you have that ability. As far as some of the other sort of nuisance complaints, I will say, just in my own living, when I was a member of the house, the neighborhood that I lived in there, I had neighbors knocking on my door asking for cigarettes. I had neighbors knocking on my door asking for rides. I had all the same things, and they weren't from group homes. They were just from the people that were my neighbors. And that's just what happened. It happened when I was going to college at Pittsburgh State. Same thing. It just happened to be, that neighborhood, those neighbors.
Sean, I need to wrap it up.
Yes, ma'am. Apologize for going over. I will stand for questions at the appropriate time.
Next, we have Colin McKinney from Starkey Incorporated. Welcome. Good to see you, Colin.
Thank you, Madam Chair, members of the committee. I appreciate the time this morning to speak in opposition to Senate Bill 316. If you're not familiar with Starkey, we provide services to individuals with disabilities in and around the Wichita area. We probably serve more than 200 people in a group home support model. We have other types of support models. They can live in their own apartment or one of our apartments, even some support for people in their family home. But a group home model allows us to meet the needs of a number of people with shared staff resources in a way that's very successful for them. As you look at the original language of KSA 12736, it states that it shall be the policy of the state of Kansas that persons with a disability shall not be excluded from the benefits of single-family residential surroundings. This bill would do that. I mean, it would critically change the position of the state of Kansas in terms of, where can one of these homes be sited. I appreciate the current concerns that were stated related to nuisance issues. And as Mr. Gatewood indicated, those can happen in neighborhoods that do not have group homes. If you've got a homeowners association, I would hope that that would be the way by which you would address those concerns. Perhaps I'll talk a little bit about, Starkey's model. We don't actually go acquire homes, retrofit them to make them accessible, and, just start a group home in an existing neighborhood in an existing home. That's not been successful for us. We have to build homes that are highly accessible, wide doorways, big showers, the driveway. There can't be any steps. And so I'm not even sure that this bill would apply to the types of support services that we provide, but I would still stand in opposition to the bill because of the limitations that it creates. It's been said a number of times, this is a narrow exception. I believe there's a map that's attached to my testimony to kind of show you what narrow exception means. And in the case of, we just picked a neighborhood and did a 1,320-foot circle to try and figure out what that would be. So if you live up near Central and Harding, you probably have no knowledge of who lives near Douglas and Pershing, but all of those are considered to be the same neighborhood, and there would be a prohibition if there is one group home anywhere within that circle, you couldn't have a second one. You may or may not believe that that's, a great big issue, but as we look at our community, depending upon where those group homes are located, you may not be able to cite another one for miles. With that quarter-of-a-mile prohibition. As you look at smaller communities around the state, a quarter-of-a-mile, radius may mean that if you have one in a given community, you could not have a second one. So what you are telling people is if you need a group home type of residential setting and you want to live in Cunningham, Kansas, it just may not be possible for you to live in that community. You may have to look elsewhere. And so there's a lot of reasons why I think this is an overreach. I believe that it's important to look at the specific concerns that are addressed. and to do what needs to be done as a neighborhood to address those. The last thing that I would offer you today is an example. We recently developed a tax credit project which involved 4 duplex homes. And we took a vacant lot and we turned it into an attractive, accessible resource within walking distance of shopping and services for the people who live there. And as part of that process, the city of Wichita required us to meet with neighbors and have a public hearing. They expressed their concerns. We addressed those and built something which I think exceeded everybody's expectations. With this type of legislation, if the city of Wichita decides to leverage it to prevent the placement of group homes within a quarter of a mile, that development may not have been able to happen. And that would be a very sad deal. It is a perfect development for the people who live there. It's a great resource for the community. We get all sorts of compliments about it, and have legislation that says you can't do that anymore, that would be sad. I will yield and stand for questions at the appropriate time.
Thank you, Colin. Kip Elliott, Disability Rights Center. Welcome to the committee.
Thank you, Madam Chair and committee members. I have not been in front of this committee, I don't believe. My name's Kip Elliott. I am an attorney with the Disability Rights Center of Kansas. We are the federally mandated protection and advocacy agency for persons with disabilities in Kansas. We represent persons with disabilities in litigation, in advocacy when it involves a legal issue. This is not a new issue for us as far as trying to impede on a person with disabilities to live in a certain area. I've listened to the proponents as well as the opponents, and I think that the opponents so far have really hit on the issues. Senator Haley talked about why is this not a local issue, and the discussion after that was that the city of Wichita anyway, or this particular neighborhood believes that it needs the state to pass a statute to protect them. That's not going to protect these municipalities or cities if they choose to implement this type of spacing requirement. The federal fair housing laws, the Olmstead, which is a famous case that involves people with disabilities, as well as the ADA, trump any type of statute that a state passes or that a municipality passes. And I think one of the things that struck me when I first was approached to look at this was, are we going to have small towns and communities in this state, and I live in a small rural county with small towns, that are going to look at this and say, oh, the state said it was okay, let's do it. And the next thing they know, they are going to be faced with lawsuits. It's not that difficult. It happens all the time. We do it all the time to file a complaint with HUD, a fair housing complaint. We have worked with DOJ in the past on housing issues, and I believe that this is not an appropriate bill to pass. And I'm very concerned that this is going to lead to a lot of litigation. In my written testimony, I did cite a case that the Department of Justice filed against the city of Beaumont, Texas. There were 2 issues in that case, and one of the issues in that case was spacing requirements. And that was, I believe, a half-a-mile spacing requirement. The city of Beaumont in the United States reached a consent decree in that case, and as part of that settlement, there was $475,000 in attorney's fees and fines that the city of Beaumont had to come up with. And that's attached to the testimony. And I've also attached a joint statement from the Department of Housing and Urban Development and the Department of Justice talking about state and local laws and practices in the Fair Housing Act. This document has a lot of really good information in it. I have had questions with and worked with city officials in the past where there's been various questions about housing issues and have referred them to this. We don't represent them, but we may have a client, and so I'll refer them to this document to start having that conversation. And this document directly addresses in paragraph 15 the spacing issue. And yes, there are some out there, but where the flaw comes in is if you put in a spacing issue or some kind of other restrictive issue, where the flaws come in is when somebody asks for that reasonable accommodation. And that's not granted, it's not looked at. I would highly recommend that this Senate bill not be passed. I think you're giving municipalities and cities the wrong message, that it's okay. And I believe that, I think Senator Dole said that this just doesn't seem to smell right, and I would agree with him on that.
Thank you, Mr.
I will
Early.
stand for questions when,
All right.
thank you very much.
If there's no objections from the committee, we'll allow off-agenda conferee to come on WebEx. Vice Mayor Johnson, are you with us? Do we see anybody on WebEx? He's there. Okay. I understand you're on mute, Mr. Vice Mayor. Why don't you let us know when he's on? Are there any questions from the committee? Yes, Senator Straub.
Thank you, Madam Chair. Being familiar with this issue, have there been any complaints to KDADs concerning some of these neighborhoods?
Who's the question for?
Let's see, who was the, is Representative Helgerson still here, or did he have to step out? Yeah, I'm not sure exactly who to direct this at because I don't know who the management company is or the disability service provider is for some of these group homes. But I would guess that some of the problems that I'm hearing may be lack of care or supervision from the management company that owns these homes. So I need a lot more information here of who owns the home. Are they for-profit? Are they nonprofit? What is the maximum rent assistance that these companies receive for each resident? Because I can absolutely see how we end up in a situation like this and how problems are created. I'm absolutely not opposed to having disabled individuals living in single-family residential neighborhoods. Thanks.
Thank you. I can speak for my neighborhood. In the case of our 8 homes, each one is individually owned by a different either LCC or other corporate entity. So we have used city services, we've used the police, we've used code enforcement. We have not pursued state remedies for the issues we've had in the neighborhood, but for our perspective, it's all the problems require us to go to 8 different facilities, and it's easier, although it's a long time, to get help from the police or from code enforcement for our issues.
Senator Horn.
Thank you, Madam Chair. 2 quick questions, if I might, for Liz Long with the Kansas Council on Developmental Disabilities. In your written testimony, you have stated on behalf of the Kansas Council on Developmental Disabilities that it would seem limiting the number of unrelated people who can live in a house, the number of cars they can own or visitors they can have, might be a fairer piece of legislation. Would that be KCDD's position on such legislation if it were brought to?
I'm using that as an example of treating people fairly. So not singling out somebody as a person with a disability, you can't live next to me. Do you understand the analogy?
Well, I do, but my specific question is, would KCDD be in favor of then limiting the number of unrelated people who can live in a house? I mean, it's there in your written testimony.
Yes.
Okay, and then limiting the number of cars?
If you think about the colleges and some of the rules that they've put around housing in college towns, I mean, that exists. People aren't being.
Right, if we're trying to, if the purpose of this legislation is looking for some sort of solution that doesn't also then impede on people's rights, then maybe these suggestions, as you've put in your written testimony, or something to look at, which is thinking that's the reason you put them in your testimony. Right. Okay, thank you. I guess that's a couple of questions. Thank you, Madam Chair.
I believe we have Vice Mayor Johnson on the line. Vice Mayor Johnson, can you hear us?
Can you hear me, Madam Chair?
We can, and we have about just a couple minutes, so welcome to the committee.
Thank you so much. My apologies for being late. We had a council meeting this morning. I am before you today to support the Senate bill, and I've heard a little bit of the testimony, but I really want us to think about this in a different way. It's about the property rights of the homeowners in the neighborhoods, and if we have clusters of these group homes like we see in the Lambsdale neighborhood, but also 3 other neighborhoods in District 1, it begins to degrade the neighborhood in the way of we have folks in a established core neighborhood who have these homes, and while they are preferred as a ranch-style home, the neighborhood and the sanctity of it goes away if you fill it with 8 to 10 or 12 different group homes. And this is about more than folks with disabilities. I agree that we need to do what we can to support those folks. But not only in the Lambsdale neighborhood, we have group homes with youth in there, some in the foster care system, some who've had troubled past, and it's fine to help out. But if you have that clustered around other youth and other types of group homes, or even in the Lambsdale area, there's at least one home that's not even really renovated for our seniors. There's a living room that has a bed in there, a hospital bed. It's not a full room. They're not getting the services that they really need in that way. And I don't think that all of those group homes have oversight. It's great that some folks do it right and well, but there's other folks who do not. And when you group those again in the neighborhood, from seniors who aren't getting the right care that they need to youth who just go around, maybe not have the right supervision there, it's a harm to the neighborhood. There's one neighborhood, doesn't have a neighborhood association. There's one group home there. All the neighbors know about it. They all look out for it, and they work together because it's just one. They look after those young people. Those young people can do yard work. It's a benefit there. But thinking about up north near Dr. Glendye Park, where we had 4 group homes, all youth, and the problems that they were having there, and the neighborhood really just wanted, again, a break to not have clusters of group homes. It wasn't that we don't want them around us or not in my backyard, but the fact that in clusters, it begins to be a problem. And that's what we've seen over in Lambsdale. We're seeing that around other parts of the city. And as a municipality, it would help us out quite a bit if we could make sure that there was a limit and they were spaced in all of our quality neighborhoods, but not having clusters of them because it's been a detriment. And that's what I've been hearing from those, and Mr. Glenn, who testified as well, that having so many together is a detriment. And it begins to erode the neighborhood that you want folks to live in. You know, people move those group homes into a neighborhood because of how amazing it is. But once you get 12 group homes in one neighborhood, it's no longer that amazing neighborhood. It's just a cluster of group homes. So I will stand for any questions. I know that there was only a few minutes, but thank you all for giving me a chance to speak to you.
Yes, please stay on the line, but we got a few more people that have some questions here. Senator Francisco.
Thank you, Madam Chair. Just want to note that nothing in this bill, or my understanding is nothing in this bill would prevent individuals with disabilities from living in other single-family residences in the neighborhood. So it would just be prevented from living in a group home, and nothing would prevent building clusters of group homes if the municipality provided zoning other than single-family for that location. But my question for Kip Elliott is, in his testimony on the first page, you talked about in a community where a certain number of unrelated persons are permitted by local ordinance to reside together in a home, the proposed spacing requirement would, in SB 316, would violate. So would we need to have both the limit on number of people and then the spacing requirement to be able to help the municipality with this?
You may very well have to go down that road. Each municipality would have to make that decision on how to do that. But that information that I put in my testimony comes directly from the Department of Justice and HUD on this joint statement. And so, yeah, I do think that you would run into that as well.
Thank you.
Last question, Senator Falscado.
Thank you, Madam Chair. My question is for Glenn, the president of Lambsdale's Neighborhood Association. In your this additional handout that you gave us, you've highlighted, you've referenced what other states did in this situation. And then if you could share, I think you shared with me a home that has about 12 people, non-related adults in there, and if you could share how much they are being charged to be in these little bunk beds. Thank you, Madam Chair.
Yes, so looking at that one, thank you. One of our homes on the corner of Polo and Edgemore recently went before the city asking for a zoning variance to go from 6 to 8 residents to a maximum of 12. They presented the city and the planning department with a floor plan that would convert the garage to a unit that would hold 4 to 5 people. This is a 2-car garage. And then the other 2 or 3 bedrooms of the residence would be cut down so that it could accommodate all the maximum of 12 people in there. So from our perspective, this was brought before and made it all the way to the city council because the planning commission, district advisory board both disagreed with this. And the city council did decide not to allow that zoning variance. This would have converted the house over to permanent group home. There's no way somebody could come in the future and buy that property and be able to afford the remodeling to turn it back into a 2 or 3 bedroom home with a place to park their garage. Senator, your other question is?
And you said they were charging $400,000 or $5,000 per person?
Yes, in some of my research here, we found that you can come into my neighborhood and buy a house in the $100,000 to $150,000 range. You can, I've had somebody who recently looked at housing and that type of things for an elder family member. They were saying the charge is about $5,000 a month. So when you multiply that to your 6 or 8 basic residents, you're looking at the ability to have revenue of $360,000 to $480,000. You take that against your staff of maybe 2 people, 24 hours a day. You don't have to pay for the nurses or any of the caregivers that come in. That's part of the insurance or Medicaid that they're charged in. And then you have money left over to handle a mortgage easily, and then maybe turn a little profit. And that whereas me trying to afford a house in the neighborhood, my money comes from my hard work. Okay.
We've run out of time. Thank you. Thank you all for being here. You all did a great job. We are adjourned.